This is the plaintiff's motion regarding parenting time. The parties are present. Ms. Viginski appears via the Zoom application. Mr. Viginski is in the courtroom. And we also have on our Zoom screen Gina Szymanski, which we'll address in a bit. Will all three individuals please raise their right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you. You may put your hands down. And this hearing, the court advised that the parties and witness could appear via Zoom based upon the potential of witness testimony, the witness being unavailable to appear in the courtroom. And so we will proceed accordingly. Before we proceed, though, again, just to stress to everyone, please do not use the child's name. You can use the child's initial if you wish. That's it. Don't use the child's name, and we'll proceed. So Ms. Viginski, do you wish to call your witness at this time?
Yes, I do. I would like Gina, who is W's therapist, to give her statement on why it's appropriate or why it's important for Wyatt to have his dog with him when he goes to his, goes to his father's.
All right. Miss, would you please state your first and last name, spelling both for the record, please?
Yep, it's Gina, Jeana. And I apologize. My married name is Burkhart, Burkhard.
Thank you. Ms. Viginski, you may question your witness. Go ahead.
In terms of your past therapy sessions with W, how has he been feeling or stating, what has he stated about his dog?
So I believe it was early January that it was brought to my attention that the dog can't come to dad's anymore. He broke down in session. He became really tearful and withdrawn and was visibly upset about this. This is a kiddo who has some anxiety. He worries a lot. I think the dog gives him a sense of comfort, security, safety in a world that he can't control. Like when kids kids of divorced families, they don't have a lot that they can control. And I feel like that gives him a sense of safety having his dog with him.
Do you feel as though it is important for his dog to travel with him back and forth like previously arranged up until the January dates with his father?
Yeah, absolutely.
Do you think it helps his emotional and mental well-being, having his dog as a support for him?
Yes, I do.
So are you recommending that his dog continue to travel back and forth with him as previously up until January?
Yes, I am.
I have no further questions.
Thank you, Mr. Viginski. Do you have any questions of the witness?
I do. So previously we had spoken and you had stated that you would support whatever the parents' decision was regarding the dog and that it was, in your opinion, not needed for the animal to travel with him. So is there a change in your evaluation on this?
I don't think that's exactly what I communicated. I think that W would be very resistant if this changed, and he would potentially refuse to go to parents' house. And I support the parents in whatever decision they make. But am I going to advocate that bringing the dog with him benefits his mental health? Yes. But I can't tell the parents what to do. Like, I can't tell you how to parent or how not to parent.
Okay. Now it would benefit him, but in your opinion, is it a necessity?
I feel like in the position we're in, like now deciding after a few years taking the dog away, I think is going to be detrimental to his mental health.
And have you seen a change? It's been over 2 months since the animal has not traveled. Have you seen a change in his behavior or? in regards?
So this is something that's brought up pretty much every time we see each other. Now I haven't seen him, and that is because of my own scheduling things, but it has been about a month since I've seen him.
He's scheduled to go next week, but
Mr. Vizinski's asking the questions at this time. You'll have an opportunity to ask more. Go ahead.
okay.
At this time, I don't think I have any more questions.
Nothing else? Okay. Ms. Vizinski, you can finish up your question.
I'm sorry, it was just a statement that he did have a session scheduled, but like Gina said, that it did have to get canceled due to a family emergency on her behalf. He does go on Tuesday next week.
All right. I just have a question then. Ms. Burkhart, this is your recommendation, correct?
Yes, I'm encouraging the court to consider his mental health. Yes.
Okay, thank you. Ms. Vizinski, any further proofs you wish to present?
No, I mean, I just have the letter that Gina had written, but she pretty much testified everything that was in her letter. I just would hope the court consider, I mean, W talks about this on the daily pretty much with me. It's never really been addressed with his father. And from, it's all hearsay what W has said, but I definitely see his mental health suffering. That is his support, that is his constant. And when he was going with him to his father's house and I would talk to him, you know, there would be numerous times that he'd be like, I'm just in my room with Trigger. The dog's name is Trigger. And I understand that Aaron will state that he doesn't take care of him the best, but I think like any 12-year-old, I don't think that, you know, necessarily they take care of things like you and I do. So I just would hope that you would consider, as it is definitely weighing on his mental health. And matter of fact, I'm actually going to talk to Gina potentially about increasing his therapy back to weekly because I have noticed a tremendous change lately.
Mr. Vizinski, do you wish to present any proofs or just argument?
Since the first of the year when the animals stopped coming, I haven't seen any negative effects on Wyatt at my home.
Please use the initials.
Yes, sorry. So, and when when the animal was in my home, it doesn't seem like he needs it. He kind of ignores them for the most part. Like there's not a whole lot of interaction. Maybe it's a comfort thing just to have him there, but there's not really an interaction with the animal. It's very occasional, excuse me, while he's there. So that's just my perspective.
All right, thank you. All right, the court has considered the testimony. The court has read the motion filed and the response in this matter. The parties have joint legal custody, and I believe it's alternate weekends, sir, that you have. Sure. And there was mention in the motion regarding some sort of verbal agreement where one party took some animals and the other party took the other animals, and there was a reported agreement regarding how that was going to work. And sounds like it was a verbal agreement, but that's not a court order, so obviously the court cannot enforce that. This sounds like an issue of best interests of the child when it pertains to his mental health. And essentially what is being requested is that the animal be with father when it's father's parenting time. And when it comes to ordering something like that, that's not within the province of the court. Certainly if it's removal of a barrier or an issue, such as an individual who may be a predator, sex offender, things like that, that may be a different story. So I cannot grant the motion to force father to take the dog. However, I will say this. The best interest of the child, at least according to the testimony I heard from Ms. Burkhart, indicates that the child is better or in a better mental state when the dog is there. Now, maybe the child doesn't interact with the dog as father thinks the child should, or yeah, as the child should, and that this is some sort of different idea or different ulterior motive. I'm not sure what it is, but the court will state this for the record. If the mental health of the child is bettered by the animal being with the child during dad's time, it would stand to reason, common sense, that the animal should be with the child on dad's time. However, I can't force a parent to take an animal. I can't. That's not within the province of the court. However, as I stated, if it's in the child's best interest that the animal be there, that would be a good sign that, you know what, maybe I should just have the dog and be done with it. That's how the court looks at it. I won't order it specifically, but I strongly recommend it. That's all I can say. And at the end of the day, certainly if there's a motion for custody or a motion for modification of parenting time and there are allegations of mental health issues regarding the child, this is something the court could consider to modify parenting time and or custody. And I don't want to do that, clearly. So I strongly encourage Dad. I know it may be a pain in the you-know-what regarding the animal, because I believe you have the cats. She has the dog. It may be uncomfortable. It may be a hindrance. It may be a bother. But if it helps the child, I would strongly suggest you follow through. That's all I can say. So I respectfully deny the motion, but I strongly encourage Dad to do the right thing. That is my ruling. That'll conclude the proceedings. Thank you, everyone. This is
Thank
the
you.
respondent's motion to terminate a personal protection order. Attorney Martin Przondek Jr. appears on behalf of the respondent. Ms. Amber Chappell appears as the petitioner in this matter, not the petitioner in the motion, obviously the petitioner in the original granting of a personal protection order. By way of record, this court had issued a personal protection order against the respondent on January 24th, 2025. There is a time requirement for the respondent to challenge the personal protection order after issuance of service. That has been timely done by the respondent. The court is in receipt of a consent contract agreement. And Mr. Przondek, is this a mutual personal protection order request?
Correct. This was, so for the purposes of the record, Ms. Chappell filed
Please
this.
stand when you address the court.
Oh, I apologize.
It's okay.
Ms. Chappell filed this ex parte PPO and pro per. She had reached out to try to negotiate a settlement with myself. I had advised her to seek counsel on this matter, which she did, which was Ms. Starr, who is the attorney on her child custody matters, I believe, although Ms. Starr has not filed an appearance in this matter. However, Ms. Starr and myself had negotiated this essentially civil protection order contract.
Okay. Thank you, sir. Ms. Chappell, you have an attorney representing you?
I do not.
I'm sorry?
I do not.
You do not? Okay. And are you requesting this? Are you agreeing with this?
I agree.
Court cannot agree though, because under MCL 600.2950, a court shall not issue a mutual personal protection order. Separate personal protection orders are correlative. Separate personal protection orders are prohibited unless both parties have properly petitioned the court for a personal protection order. So I cannot grant this. The personal protection order will stay in effect unless the petitioner wishes to have it removed. However, and I can't provide legal advice, but I think the only thing that can be done is if there is some sort of consent agreement regarding contact between the parties, it could be done in the Tuscola County case, where the Lapeer County case. I believe it's in Lapeer. There's a domestic relations case in Lapeer County that can be, I'm assuming there can be some sort of consent agreement there regarding contact. But, and if that happens, and if it's something that the parties agreed to, then the petitioner can come in and ask personal protection order be terminated in this court, then the court will do that if there's sufficient evidence to do so. That's all I can do. I'm not allowed to issue a mutual restraining order under the law. Any comment by either party?
I mean, we already kind of have a no contact order through the pier. So I guess that just remains in effect. And then I guess I'm just having a question. So that still remains in effect when we have it with Pierre County. Because we have basically no contact already.
Well, does it have all these provisions in it?
It does. I have a copy of it. It doesn't, but it does state that we are required to go through a parenting app and that we do all of our exchanges through daycare so that there isn't any contact. And then in the event a third party is not available, we meet at a police station.
Okay. I can't render legal advice, but all I can suggest is to address this matter in the Lapeer County case for a mutual agreement. If there's a mutual agreement reached and you wish to terminate the personal protection order, simply file the motion and the court can address it.
Okay.
Okay. That'll be all. Thank you. Time and date set for proceedings relative to a domestic relations matter. Mr. Camps is present. He's in pro se. However, he is a licensed attorney, P number 68561. Court calls Ms. Torres. No response. I have a question, though, regarding the default in this matter, because there was a request for default and request an entry. That request was done on December 19, 2024. The default entry was entered on December 27th, but it says certificate of mailing on December 23rd. So how could the default have been sent on the 23rd when it wasn't even entered until the 27th?
Judges, I do have a copy of the default and request of entry. It looks like what happened is that my legal secretary sent it a certificate of mailing on the 23rd, and then that the family court clerk also mailed it on 12/27/2024. And so it would appear to me that the court clerk entered it that same day, 12/27/2024. So it would appear that it was sent twice, once by our office, and then there's also an amended or an additional signature of the family court clerk that it was sent on 12/27/2024. I do have a copy of that certificate of mailing if you would like me to approach with it, Judge.
You're an officer of the court, sir.
Yes, sir.
You're an officer of the court. So if you say it and it's there, it's there. So we can proceed.
Thank you, Judge.
You're welcome. And you may be seated, sir. Would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Sir, please state your name for the record.
Peter Camps.
Mr. Camps, you're the plaintiff in this matter, correct?
I am.
You are also a licensed attorney?
I am.
Do you practice in domestic relations matters?
I do not, Judge.
Okay, we'll walk it through then. Have you lived in the county of Huron at least 10 days, in the state of Michigan at least 180 days immediately preceding your filing this complaint for divorce?
Yes, Judge.
At the time you filed this complaint for divorce, was Ms. Torres a resident of Huron County or was she a resident of Orange County, Florida?
At that point, she was not residing in Huron County. She was residing in Orlando, Florida, where she has been for at least 2 years.
All right. And is it true that you were married on January 14th, 2019 in Jamaica by a person authorized to perform marriages there?
Yes, Judge.
And the parties have always maintained the same names as I've recited just a few moments ago, correct?
Yes, Judge.
And are there any minor children of this marriage?
No, Judge.
And as far as you know, is a defendant currently expected?
No, Judge.
You've alleged in your complaint for divorce that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved. Was that true at the time you filed the complaint?
Yes, Judge.
Still true today?
Yes, Judge.
Briefly, in your own words, can you state to the court why you feel the marriage cannot be preserved?
There's been a marital breakdown, and there is no chance of reconciliation at this point.
All right, you answered one of my questions. But if the court did not grant you an absolute judgment of divorce today, would you be willing to resume a husband-wife relationship with the defendant?
No.
Do you have a proposed judgment?
I do, Judge.
Would you please present that to the court?
Yes. May I approach?
Yes, you may, please.
I do have 3 copies of
That's fine.
proposal.
Thank you. You may be seated, sir. Your proposed judgment indicates that neither party would be awarded spousal support and the issue is forever barred, correct?
Yes, Judge.
And as it pertains to any beneficiary rights, any rights either party has to the proceeds of other benefits in any policy of contract of life. Okay, so basically anything relative to life insurance, carrying any cash value, retirement income, pensions, annuities, retirements, each party would receive that free and clear from any claim of the other, correct?
Yes, Judge.
And you already addressed retirement accounts, and there's profit sharing as well. I see here listed retirement accounts, statutory pension, and profit share. So if there are any profit sharing issues, each party be receiving whatever profit sharing is in their respective.
Correct, Judge.
Okay. Each party be awarded the personal property currently in their possession, free and clear from any claim of the other.
Yes, Judge.
If there's any debt owing on that property, the person receiving the property assumes the debt. The other parties held harmless and indemnified therefrom.
Yes, Judge.
Do you own any land?
I own a home, Judge. Yes.
Oh. Each party be awarded the real property currently in their name and possession, free and clear from any claim of the other.
Yes, Judge.
And does the home have both names on the deed or just one?
Just myself, Judge.
Okay. Each party be responsible for the debts in their respective names.
Yes, Judge.
Surviving spouse rights would be extinguished as to both parties.
Yes, Judge.
Regarding the property that I mentioned ago, are you holding any property of hers or is she holding any property of yours?
None, Judge.
Any other marital debts, any marital debts or assets that you're aware of that we've not addressed?
No, Judge.
Thank you. Based upon the testimony presented, the court finds that the statutory grounds for divorce have been established. Therefore, a judgment of absolute divorce is granted to the plaintiff, Peter N. Camps, from the defendant, Andrea Alejandra Plaza Torres. I make a finding there are no minor children parties. Neither party is awarded spousal support. And I maybe I failed to ask that. Neither party would be receiving spousal support. Right?
That's correct, Judge. Thank you.
All right. Court will order that. The divorce judgment shall include the property division as outlined on the record, as well as any and all provisions concerning pensions, life insurance as well, and all other provisions contained within the judgment. Court will execute the judgment that has been presented in this matter. And Mr. Camps, what will happen next is I will give you the judgments. You can take those to the clerk's office, which is right around the corner there. And the staff will get those processed. You'll be able to get your true copies today.
Very good. Thank you,
Any
Judge.
questions?
I have no questions, Judge. Thank you.
All right. Thank you. If you want to just have a seat back there, and as soon as I finish this, we'll hand you the documents or ask you to approach, and then you'll be all set.
Very good. Thank you, Judge.
Receive documentation, information, medical information that is confidential, but the court did review it. And based upon my review, I see nothing from the kidney doctor that says that this medication or the reasons for prescribing this medication. So, well, actually, let me place both parties under oath. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Yes.
Thank you. So I reviewed the documentation that has been submitted, as I stated, and I was very specific last time about what I was looking for regarding the reasons behind authorizing, or it's not necessarily prescribing, but authorizing the use of medicinal marijuana by the minor child in this case. Ms. Goki, do you have any documentation from the kidney doctor regarding this? Because I didn't see it.
I'm still working on some stuff.
Sorry?
Still working on some stuff.
All right. Well, it's not in the file, and the prior orders will remain in effect. No medicinal marijuana for the child, and that continues until the court receives the documentation that the court can consider. If I don't receive, the court does not receive the document within 30 days, the order will become a final order in this matter. And that's how we'll proceed. Do you have any questions, Ms. Gold?
No.
Sir, do you have any questions?
No.
All right. 30 days from today would be what? Let's make the cutoff April 11th.
And then have some function for that Friday or the 18th, because it's good Friday, so
April 25. Okay. Well,
April 4 or April 25.
let's see. Oh, that's right. I'm just going to set a cutoff date, even though the court will not be hearing matters on April 11th due to the holiday. If the court does not receive documentation, appropriate documentation by April 11th, this order becomes final. If there is documentation that's provided, the court will then review it, and then we can set a hearing after that. Any questions?
No.
Sir, any questions?
No, sir.
All right, that'll be all. Thank you both. Record indicates to the court that Mr. Tucker is to be sentenced for domestic violence on the child on March 11th. Is that correct, sir?
Yes, sir.
Okay. As a result of that, at this point, I need to find out, the court needs to find out what happens at the sentencing. Specifically, is the defendant placed on probation? Is the defendant issued a fine? Is a defendant ordered to county jail time? I don't know that. And as that is hanging over the proverbial head of the court, we need to adjourn that proceeding. So we will not proceed on the parenting time matter today. That issue is preserved. After you've been sentenced, I will ask you, Mr. Tucker, to renotice this hearing. Do you know what I mean by renotice?
I do not.
Okay, this is not legal advice. All renoticing is to contact the county clerk to say, my motion was preserved, which I'm ordering today.
Okay.
And that you wish to have the hearing set on a particular Friday.
Okay.
And then notice obviously has to be provided to Ms. Marr, and then we can have our hearing on parenting time. Does that make sense?
Yes.
You understand it?
Yes.
Okay, thank you. So it's preserved. Let's talk about Ms. Marr's motion regarding, and you referred to it, Ms. Marr, in your documentation without the list as stuff, right?
Correct.
What are we talking about here?
Don't have it in front of me actually, but there was a list of stuff on there, that he had wanted, from his dad that was sentimental to him, that would help him with daily, like, it's sentimental to him, so it would help him having it.
Okay. And according to this, my son is asking for his stuff his mama, Sarah, grandparents on her side, Sarah and my mom, has gotten him. You're asking for stuff he has a special connection to. And you do have a list. Oh. Nana blanket, Disney hoodie, Dogman books, necklace from wedding, John Deere hoodie, big Pikachu, Ohio State hoodie, Michigan fan.
My soon-to-be ex-wife is from Ohio.
The enemy of your enemy is your friend, being a Spartan. So,
Right.
Lion King back and a Pokemon hoodie, right?
Correct.
Okay. Mr. Tucker, what's your response to this?
To be honest with you, I did not bring any of that stuff with me because like everything going on, my mind has been scattered, like we're trying to work and
That's fine, but do you have any problem with providing these two?
some of the stuff I do, like the blanket and stuff like that, I don't have an issue with, but like the John Deere hoodie, I personally bought him for Christmas and I was kind of hoping to maybe just keep that at my house. The Disney hoodie, yes, his Nana did buy. I do not have an issue giving him that.
Okay, so let's go down the list then. You don't have any problem with the Nana blanket?
No.
Disney hoodie?
No.
Dogman books?
I have bought most of those for him for Christmas, and I would prefer to keep those at my house for when he does, if and when he does get to come back.
Okay. Necklace from wedding?
He can have that.
Okay. We talked about the John Deere hoodie. The big Pikachu?
I do believe I personally bought that myself too. But I mean, if
will help him, then yes, I will let him have it.
Okay. Ohio State hoodie,
He can have it.
Lion King book,
I guess I'd have to look through all of his books and look because he's got a lot of them.
and the Pokemon hoodie.
If it's the one I'm thinking of, it's a giant hoodie that zips up and it looks like Pikachu. If he wants it, yes, he can have it.
Okay, so everything except the Dogman books and
The John Deere hoodie.
the John Deere hoodie. Does that work for you, miss?
Yeah, that's fine.
So ordered. When can the property be transferred? Because I
Because
believe there's a no contact provision in the Tuscola County case.
that has actually been lifted. Lifted at my pre-trial. I didn't get a chance to come in with, like I said, with everything going on with trying to work and stuff like that. Tuscola County judge said that as long as I can have, or we can agree to have safe contact and visits with the child, then he has no issue with that.
Good, okay. How many days, when could you have this property to,
If she wants to meet me in Bay City tomorrow, if I don't have to work, I can have it to her tomorrow.
That's fine.
okay, by tomorrow?
And I will unblock her off my phone so that way if something changes, I can let her know maybe Sunday.
That would be helpful. Do the parties communicate via app close?
I do not believe that app close is ordered for the parties. Historically, they haven't had a need for it. I think at the time it would be.
Okay. You both familiar with that app close?
I still have it on my phone.
I sent him an invitation already, but I'm blocked, so.
Well, sounds like you're gonna get unblocked here in a moment. I'll order the use of app close. That's how the parties are to communicate absent any emergency. So you can communicate back and forth with that regarding where you meet in Bay City, except for the Dogman books and the John Deere hoodie, as I understand it, the items will be returned. Or I shouldn't say necessarily returned, provided to Ms. Marr. Any questions, sir? Miss, any questions?
Is there still no visitation right now?
Right now, I'm maintaining the order that this court entered previously. Because sentencing is what, next week?
Next Wednesday, yes.
Yeah, next Wednesday. So after next Wednesday, let's see where we're at.
Okay.
And then if you have an idea what happened, sir, obviously you'll have the idea. But if it's probation or whatever the court may order absent county jail time, you can renotice this and we can, or if you have a mutual agreement to lift it, certainly you can present that to the front of the court and the court can enter that if it's in the best interest of the child.
Yeah, I have my attorney that I had over there. She sent me the whole thing of everything that the judge said. I can, I'll just have to figure out how to print it out or maybe I can forward it, email it.
Well,
I think he's referencing the Tuscola case. I have the bond conditions that are currently in place. I requested that from the court. I believe the misunderstanding is as it relates to the parenting.
right. I'm going to keep, well, wait a second. Yes, I'm going to maintain the order. Let's see what happens on March 11th. And then if the parties have an agreement that they want to have time, you could bring it to the front of the court. If neither party agrees, file the motion, which you've already done. We'll hear it then.
They wouldn't need to file a motion, Your Honor. I would just go forward with issuing a recommendation as has been ordered.
Okay, that's what we'll do.
Can I at least talk to him? Like, is there no contact order still in effect is what I'm asking. Like, if I unblock her, can she call me later when he gets from school and I can talk to him, or is that still?
Does that violate the order in Tuscola? It doesn't?
No,
Do you have any objection to that?
I don't, as long as the child wants to talk, I have no problem with that.
I'll order that then.
Okay.
I appreciate
Parties
it.
agree.
Can I add something else?
Sure.
I filed a motion, response to his motion. Can I just give him the copy of what I did, because his copy's in here?
Oh, yeah, you can provide that.
Okay.
Yeah, you can provide that to him.
It has medical information about the child in it.
Okay, you acknowledge receipt of the documents, sir? That's the acknowledgement to me. Okay. Good luck to both of you.
Okay.
That'll be all, off the record. 6784 DM. This is the defendant's motion alleging a violation of the judgment of divorce. Mr. Pomeranke is present. Court calls Elizabeth Howison. A response matter is scheduled for 9 a.m. It's currently 9:52. Mr. Pomeranke, would you please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
Please state your name for the record.
David Michael Pomeranke?
Mr. Pomeranke, you filed this motion, correct?
Yes, sir.
And you filed it with the clerk of the court?
Yes, Your Honor.
All right. Before we proceed on the motion, the court does not appreciate you telling court staff to shut up.
Who did I tell to shut up?
Court staff reported to me that you told court staff to shut up.
No, I did not. I did not say shut up to anyone.
Okay, well, do you need to call in the court employee to address that?
I guess if you'd like, because I didn't say anything to no one.
Okay.
I was talking to my significant other about other stuff.
Okay, stop.
I apologize, and I said I'm sorry. It slipped out. It's human nature, and I apologize.
It's not human nature as far as the court's concerned. I have to restrain from using that language. You need to as well.
Yep.
You have an understanding. Please, even though you deny it, and I'm not here because I didn't see it, I didn't hear it, but it was reported to me. If you did it,
any staff
excuse me, sir. Don't do that, please. That's all I'm asking.
Yes, Your Honor.
Just be respectful. That's all I'm asking.
Yes, Your Honor.
Thank you. I appreciate it. You've alleged in your motion, Ms. Palmer and Ms. Howison is not here, the window loan, that the window loan has not been paid. Is that correct?
Yes, Your Honor.
Okay. Do you have any records or anything to indicate the same?
Yes, I gave a copy to the court's clerk office of like everything that I've got from Foundation Finance.
Okay, and that's dated January 27th, 2025?
Yes.
Okay, it's in the court record then.
Yes. Also, I have in there a copy of our judgment of divorce and
the court reviewed that.
Yep.
Now, it appears that this has not been paid since 2021.
Correct, Your Honor. I was the last one to make a payment on it on 9/21 before I was incarcerated when she had taken over the house. And she was supposed to take over the payments. And then the judgment of divorce was ordered in 23. And that was over a year and some change ago, and she still has not made a payment. And Foundation has called me and can't get a hold of Ms. Howison. And I'm deemed indemnified and not held responsible for it, and it's ruining my credit.
What are you requesting of the court then, sir?
I talked to Foundation Finance. It says right here the payoff amount is $11,956.08. That's what they want in order to get my name off the loan. And I don't know what else to do in this matter because it says in the order she was supposed to pay it and she has not paid it.
Okay. What the court is going to do, Mr. Pomeranke, is issue a show cause for her, which means that she'll be required to come into this courtroom. She should have been here today.
Nothing's going to happen about that for her not showing up. Well, that's a contempt.
At this point in time, I need to have the information for her. The show cause could be a contempt, but I have to show cause her first.
Okay.
I'll show cause her. The court sua sponte on its own initiative will show cause Ms. Howison. She must appear at the next court hearing, and she could be held in contempt at that hearing.
Okay.
I can't proceed on contempt at this point until I hear from her. But in the meantime, I will require her appearance at a future hearing, which will be sooner than later.
Okay.
Any questions, sir?
No, that's it.
All right. Thank you. For the court. There's a motion regarding attorney time, as well as a show cause regarding alleged failure to appear at a hearing. We'll begin with that. A show cause was entered on March 12, 2025. There was a hearing scheduled previously. I believe that would have been, sorry?
It would have been, our court hearing was March 7th.
March 7th, okay. I'm just trying to find that. I appreciate that. Trying to find the notice here. Ms. Schultz, do you see that as well?
Mr. Pomeranke's motion was filed and signed by the town clerk's office as of January 31st, 2025.
Got it. I just found it. Yes, thank you. This is an alleged violation of judgment of divorce scheduled for March 7th, and there was a certificate of mailing on January 31st. 7 days. Correct?
The January 31st filing was set for hearing on March 7th. It was more than 30 days notice.
Yep. Okay. And both parties, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Ms. Howison, you did not attend the hearing.
I did not.
Why not?
I never received a notice of hearing.
I'm not going to go through the total address, but it's still 987, correct?
Yes, but that's not the address that it was sent to either. So,
Well, the notice of hearing indicates that.
I reached out to the court. So Monday, March 10th, I received a notice to appear via my mom's address, to my old name and my parents' address, that I didn't show up to this March 7th hearing. So I immediately emailed the court and Mrs. Schultz and Maria Hobecki that I never received anything, a notice of a 3/7 hearing via mail or email, and that had I known about it, I would have absolutely been here. And then I went back Tuesday, the next day, Alicia from the court emailed me that Mr. Pomeranke filed it on January 31st, and she mailed it to 971 Lakeview Drive.
She mailed it to 971?
That's what she told me. Alicia Thomas, I believe. I can look up the email. And at which point I asked her, I said, okay, well, that's not my legal name or my legal address, but that's fine. I don't know why I didn't receive it, but I also asked why it was never emailed, as everything else has previously been emailed also. So, but regardless, I never received this, this letter, and it was mailed to 971. My mom is here to also say that it never came to her house. If it would have.
Do you have the documentation?
What documentation?
The documentation of the notice of hearing sent to 971.
Like that the court told me that?
No, do you have the documentation? You claim that it was mailed to your parents' address.
Right.
Do you have the documentation with you today?
It never came to my parents' address. That's what I'm saying. It was, they said it was mailed to my parents' address, but I never came to there either. I did not know about this. I never received this document.
Because the notice of hearing has 987. I don't know why the county clerk would send it to another address.
And I did address that with the county clerk, and that was the last conversation that I had with her. I did say it even, because she finally emailed it to me, what was sent. I didn't know anything about what this even hearing was about. And at that time, I said, Mr. Pomeranke, even, you know, his address is on there. My address is listed as 987, you know. And then furthermore, she said something about me updating the address, because I asked them how they even got that as my address, the county clerk's office. I've never legally resided at 971 in many, many years.
Right.
So.
Well, we need to have the deputy clerk here. Bring it to Thomas right now. And while we're looking, I see that today's hearing, certificate of mailing indicates 971 Lakeview.
Again, Your Honor, I don't even understand how the county clerk has that as my address. And she said her response was something about that I needed to change it if I changed it with the front, but I've lived at 987, my legal address at 987 for 10 years now. I mean, I don't know.
Ms. Thomas, would you please step up to the witness stand?
Sure. This case is the truth, the whole truth, nothing but the truth, so help you God.
Yes. Please be seated. Would you please state your name for the record?
Alicia Thomas.
And Ms. Thomas, are you employed?
Yes.
In what capacity?
Currently, I'm the deputy election clerk. Previously, I was a family court clerk.
Okay. Were you in that position, the previous position, back on January 31st of this year?
Yes.
Okay. I'm handing you a notice of hearing and motion. This is important. This was filed by Mr. Pomeroy.
Yes.
Take a look at that. And do you see the address in the top right for the, it's really supposed to be the plaintiff, but he lists her as the defendant.
The 987?
Yes.
Yes,
Okay. Now, at the very bottom, there's a certificate of mailing.
yes,
And did you mail out the notice of hearing to Ms. Pomeroy?
correct.
I'm sorry, to Ms. Howison?
Yep.
And what address did you use?
I mailed it to the 984 and then I also mailed it to the 971, I believe. Whatever address that we still currently had on the system.
So you sent 2 notices?
Yes. If the addresses aren't the same than what the people write on the form, and I should have wrote that, I send it to both just to make sure that they get the correct information.
Okay.
And I let her know in the email that I did email it, or that I did mail it to both.
Okay. Well, you let, I'm sorry, you said something about an email?
Yep, I emailed Ms. Howison last week, letting her know that I did mail it out to both addresses.
Any other questions, Ms. Howison?
I would like to read the email.
I can go print it out.
That's fine.
Well, that was last week, correct?
Yes.
Okay, well after the motion is filed. Do you have any questions regarding the questions the court posed, Ms. Howison?
Is she printing the email or can I read this? I have the email from her. Good morning. A motion was put through by Mr. Pomeranke on January 31st and I mailed it out the same day. It was mailed to 97. This motion was not put on by his attorney. I can email over a copy for you. We do charge $1 a page. That's
Okay.
the email I received from Ms. Thomas.
Yep, that was the one that was like 2 weeks ago, but the latest email that I sent, which was last Thursday or Friday, it said that I had mailed it to both. The address that we had on file and the address on the mail, on the paperwork.
Okay, but I don't understand why you didn't say that to begin with. I mean, I was asking about it.
I probably didn't add it, I was probably busy at the time.
Okay. So regardless, I mean, I never received this letter. I mean,
Well, do you have a question? I'm sorry. Because I know you stated that. Do you have a question for Ms. Thomas?
No, I don't have any questions for Ms. Thomas.
Okay, I do. No doubt in your mind, you mailed it to both as of the certificate of mailing January 31st.
Correct.
Both addresses.
Correct.
You may set that. Any other comment, Ms. Howison?
I mean, about all of this in general?
About failing to appear.
Okay, I did not receive a notice of the court hearing on 3/7 to either address.
Okay. Well, we had an officer of the court testify to the contrary. She further testified under oath that she mailed to both addresses. As a result, notice was properly filed in this matter, and I find you in contempt for failing to appear.
Could it have been lost in the mail?
That's not in the court rule. Proper service is conducted as soon as it's placed in the mail.
With all due respect, Your Honor, we have been doing this a very long time, and I'm very well aware of what can happen if I just don't choose not to show up for a hearing. I swear to God and everything, if I had notice of this hearing, I would have been here. Why would I want to cause more stress for myself or disrespect this court?
Oh, I'm not finding any disrespect with the court. It's a matter that a notice of hearing was filed. It was properly mailed according to the testimony of the clerk, as well as her previous oath that she administered. Father appeared. Obviously, you did not appear. You claim you did not receive it. I'm not saying whether you did or didn't, but service was proper under the court rule. That's what the court has to follow. Is there anything you'd like to say before the court imposes disposition?
No.
Thank you. The standard $100 fine will be imposed. That'll be due April 11, 2025.
May I add something, John?
What's your question, sir?
This is not the first time she missed a court order appearance. She missed 4 depositions. Well, that you have ordered throughout her divorce trial. She missed 4 depositions and then.
Right, but this is one that she missed for you in this court proceeding. Depositions are different.
Okay, well, okay. I didn't know. All
But
right.
she's, and that's paid in front of the court office. Sure, and we placed both under oath. What's your motion regarding hearing?
I was on my daughter's TikTok and just doing my parental checks, making sure she's not talking to nobody she's not talking to, supposed to be talking to. And they were in the car with alcohol. And our order of divorce states there's not supposed to be any alcohol 8 hours prior to having children. And I printed off a copy, a picture, and I sent it to Mrs. Ms. Schultz, and I also have a copy that I printed off last night at Walmart.
Okay, so you have a photograph with you?
Yes, the court's due is from Miss.
Well, I don't.
Ms.
know
Schultz,
whatever-
I'm sorry.
That's okay.
It is attached to the show.
It is attached, okay. Oh, that's right, it is. Okay. But it's not for the court to consider at this point. Have you seen the photograph, Ms.?
Yes,
Okay, any objection to the court reviewing it?
no,
Okay, sir, we'll take it. We'll have it marked as defendants 1. It's admitted.
There's 2 photos, one email black.
One's black and white, one's color. Any problem with both of those? I've not looked at it.
they look like different photos. Your Honor.
Well, which one do you have any objection? Which one do you have an objection to?
I'm just pointing out that they're different photos. You asked if I've seen them and if I would object to them. I've only seen one photo. I've not
Okay,
seen both photos.
I want you to see both. We'll hand them down for you to look at.
Thank you. No, I have no objection, Your Honor.
Okay, thank you. Appreciate that.
Yes.
We'll consider them 1A and 1B. Okay. It's admitted. Sir, do you have any idea when this photograph was taken?
It's a TikTok video, so it's a screenshot of the video that's on TikTok.
Okay. Does it indicate on the TikTok app when this was taken, if you know?
Can I go on and look quick?
But
I don't.
That'll refresh your recollection.
Just give me 2 seconds. February 21st, it says. 2/21, it says on that.
February 21st, okay. And you're offering this, it's admitted that it's a violation of the court order, correct?
Yes.
Anything else?
Yes, I had also was going through my son's phone and I found pictures of more alcohol. It's just chilling, just sitting in the hallway. And I emailed, and I think Wednesday or Thursday, Ms. Schultz, sorry. I emailed Ms. Schultz Wednesday or Thursday with it, I think Thursday, yesterday. And let her know. She told me to bring it to court today.
Do you have photos of those?
Yes, I have one photo.
Would you like to show that to this house? Please show. Any objection to the court reviewing that photograph?
Okay.
Sir, would you like to present that to the court reporter? And that'll be marked as well as plaintiff's chief.
We'll give it to him.
Sir, anything else you wish to present on this issue?
No, Your Honor.
Ms. House, your response, please.
My response is I don't know when or where this photo was taken, nor am I consuming any alcohol in the picture/video. I'm not even in the photo. Further, based on what he was just saying, there's really no way to know when a photo was taken, only when it's posted. But I didn't realize the date in question. He just reported that it was taken on February 21st, which was during his parenting time, actually. Again, I don't know. I don't know. I'm not consuming alcohol in the picture or video. I did read through the motion as it was presented with the email exchange from Mr. Pomeranke and Ms. Schultz, stating that she had reviewed it and did not see an indicated of alleged order violation because the JOD provision is that under neither party consume alcohol during parenting time. Again, I'm not consuming any alcohol during parenting time. This is not proof of that. As far as the second picture that he just sent now, saying that it was from my son that took that photo. I don't know when or where this photo was. Well, I know where it was taken. That one is in my hallway. I don't know when it was taken. Brendan comes and goes all the time, and, it could have been on my own personal time. However, that's still not my alcohol, but, and still not proof of me consuming alcohol. I guess that's really what I have to say about it.
All right, thank you. Any rebuttal arguments, sir?
No, just one thing, Your Honor. It was actually posted 17th. I'm sorry. Which would have been her parenting time, and it's her vehicle. I don't own a vehicle.
Okay. Any other rebuttals?
No, alcohol has been an issue with her. I'm going on 5 years this November, this August, and 1 year or 2 years, no smoking cigarettes, November.
What page is in the judgment, the prohibition attorney? I'm trying to find it.
Our written opinion and judgment of divorce isn't numbered, Your Honor, but it would be 7, approximate, the second paragraph above communication.
Oh, I'm looking at the child support order. When was that judgment entered?
July 18th. And the provision at issue, Your Honor, is that neither party shall consume any controlled substance except as legally prescribed, nor shall either party consume alcohol 8 hours prior to or in during any such.
Okay. All right, the court has received evidence in the court, in the record, specifically regarding alcohol reportedly possessed by the plaintiff in this matter, one of which appears to be in a motor vehicle because I see a seatbelt, and clearly, as I move my glasses, that's a White Claw emblem, which would indicate alcohol. The second photograph is a case of Miller Light beer as well. Can't tell whether it was opened or not. It doesn't appear to be, but I'm not sure. The allegation from father is that mother violated the terms and conditions of the judgment of divorce with possession of alcohol while the children are present. And the order, the judgment, indicates that neither party shall consume any controlled substance except duly prescribed, nor shall either party consume alcohol 8 hours prior to it during any custodial time. There's been nothing presented on the record to indicate that consumption had been done. Clearly possession, but that's not prohibited by the judgment of divorce. As a result, the defendant has failed to sustain his burden in this case, and the show cause is respectfully dismissed and denied. That'll be all. Thank you, everyone.
Now we have one more.
Oh, I missed one?
Yeah, for
There's 2 more.
judgment of divorce issue.
Okay, what's the second issue then? I apologize.
There's also the issue of the school year parenting time.
Oh, yes, I forgot about that.
And then Mr. Pomeranke has a property.
Okay, I completely forgot about that. Let's talk about the custodial time. And I believe what Mr. Pomeranke was looking at was a modification of that to keep the days contiguous with the overnight, correct?
Yes.
Okay. And what is it that you're proposing, sir?
Getting rid of the Wednesday overnight, adding it to my weekend time. So instead of going back Monday after school, they go back Tuesday after school. The least interruption for the kids. We're doing that now. It's enjoyable. It's not, they don't have to go back Monday, pack up, come back to my house on Wednesday. It's just smooth flow, and it hasn't been an issue.
So you wanted to put it at the tail end?
Yes, but on tail end, I had conversations with Ms. Howison on AppFlows, sent them to Mrs. Schultz. She agreed. Didn't matter if we put it in the beginning or end. I said, okay, I choose the ending. This way it just flows, no big deal. They just stayed in my house one more night. And she said, no, you're not gonna do that, because that's not what I chose. And I got told, no, it's on AppFlows, and ask Ms. Schultz. She told me no, and she told me yes. because that's not what she wanted.
Okay. This is your response.
I'm sorry, I was just reacting to that I don't speak that way, but anyway. So I was a bit caught off guard by this. I didn't realize that we had any issue as we've been doing it. The kids have been going Thursday to Tuesday for 3.5 months now or whatever. Mr. Pomeranke and I began talking about this back in the beginning of the school year. We both absolutely agreed that the children do not like to come home Monday and go back on Wednesday. It's kind of an upset for them and they haven't enjoyed it. So immediately, you know, I just said, we'll figure it out. And so he said, I would like to do it Thursday to Tuesday. And I said, well, I would like to do it Wednesday to Monday if possible. It doesn't really matter if they go a day earlier or stay a day later, in my opinion. So I just asked him if we could, and he said, no. He's the one who said, nope, Thursday, Tuesday only. So I said, can we try it both ways? I think they have posts, well, some of the have posts attached because the whole conversation isn't in there, but multiple times.
Statements between the parties, if you come up with an agreement on your own, unless it's court ordered, the court can't honor it. I mean, you can agree to whatever you want to agree to, but that if it doesn't follow the court order, then the court order still trumps. So I guess my simple question for you is, do you have any problem with doing it at the tail end rather than the front end?
No, I don't. And that's why I'm just explaining the whole thing because the other accusations in this motion was that I'm, you know, causing problems or whatever. I mean, you could.
Well, I'm trying to cut through the chat.
Yep, go ahead.
So all I'm asking is, father wants to do it Thursday to Tuesday, right?
Yeah.
Do you have any problem with that?
No, but I would like it noted that I was trying to do a compromise.
No. Again, I'm cutting through that. Remember the whiteboard story?
Yep.
Clean
I would
slate.
just like it noted that I tried to compromise and he said no. So yes, I will give him his way. It's perfectly fine that we do Thursday.
Well, it's not a matter of giving it, just a moment, guys. It's not a matter of giving him his way. It's what's in the best interest of the children. Because you told me as well that it appears that the children like this way, doing it that way rather than plucking them out one night during the week. Right?
Right.
Let's
They
go with that.
would just as well.
Let's just go with that. Best interest. I agree with it.
And it would also be in the best interest of the children to do Wednesday to Monday. It's no different whether it's the beginning or the end of it. That's the point.
Right.
And I'm just making note because it's been a continuing thing that I was
Okay,
reasonably trying to
Ms.
compromise.
Howson, I'm going to interrupt. You stated that you felt you had no problem. I don't care about the communication between the two because I know how bad the communication has
I
been.
know, and that's.
But
the point I'm making.
excuse me, please. You find acceptable the Thursday to Tuesday, right?
I do.
That's what everyone agrees to. Let's just go with that.
Okay.
Court finds it's in the best interest, and we will modify the order to reflect that effective. Oh,
Just for clarification, if the court can confirm whose weekend is currently with the kids, so we can put a baseline order.
Or spring break, so she gets spring break this year.
Who had last week?
I did.
okay, got that.
Yeah, it is my regular weekend, regardless of. street.
Okay, what about the property issue, sir?
She was supposed to take care of the home window loan and did not.
That's right, that's the old motion.
Oh, it's been over a year and it hasn't been paid on in over 3. I was the last one to make a payment when I lived in the home. Before I got incarcerated. She has not made a payment since. Everything, I sent all the payments. Last payment was September 2nd, 21, which was 2 months before I went to jail. I paid it and it hasn't been paid since. She agreed to it in court, saying that she would take all debts held liable with the home, and she would happily take it. That's exactly what said. And had not done anything to take it out of my name. I've called foundation. I can't physically do it. They won't let me do it unless she acquires her own financial loan or financial term, whatever, to take the loan over, to pay the loan off. Now they won't accept that because it's past it. They closed it. It's not closed, but.
Remind me, was that in your name originally or was it both names?
Both.
What page, because I do recall that, but what page on the judgment of divorce is that reflected?
I printed off a copy. I think it should be with it of the order. I have it here. I printed off the order that states that I'm supposed to be held indemnified and harmless from the home loan.
Well, we don't have the page number on that. That was my fault.
I don't have it on this either. There's a highlighted area in the middle. Straight line.
Okay. Ms. Howison, what's the status of that loan?
9/2/21 was Dave's one and only payment on this loan that he was previously ordered by this court to be responsible for in our original judgment of divorce on August 13th, 2021 until the second judgment of divorce entered on July 18th of 2023 for 2 years.
Well,
No payments-
that order was
no
vacated.
payments were made by
Excuse me,
him.
miss, that was vacated. The note, the judgment of divorce indicates there's also another encumbrance on the home, specifically a window loan from Foundation Finance with an outstanding balance of $11,956. Plaintiff states that the parties are currently behind in payments based upon correspondence received in July 2022. Clearly, the debt owing on the marital home exceeds the value of the home. Based upon the evidence presented, it's hereby further ordered that plaintiff shall be and hereby is awarded the marital home subject to the underlying mortgage and window loan, and shall hold harmless and indemnify the defendant from both mortgage and window loan. It's your loan.
Correct. Following our most recent judgment of divorce on July 18th, 2023, it was deemed my debt and I called them to handle it. There's no way to take his name off of the loan. They don't do in-house refinancing. This loan has gone to collections and was charged off, which I was trying to just make a point during the time that it was Mr. Pomeranke's responsibility. The only option to get his name off it is to pay it in full. There's no way to bring the loan current since he let it go to collections, and it stays that way until the payment is paid in full. So paying on it now brings the balance down, but it still shows a negative on both of our creditors' reports until paid off. So I am paying on the loan. I'm willing to continue paying on the loan moving forward. I do not have access to $12,000 right now to pay it off in full to be able to remove his name off. I don't know.
What have you been making on payments?
I just resumed making payments now.
When? Just now?
Yes.
Well, hold on, I'm still asking questions here. So this order was entered on July 18, 2023.
Yes.
And you're telling the court that you've not made a payment until 2025?
No.
You were not saying that, or you are saying that?
I am saying that.
Why was there payments made after the order was judgment was entered?
With all due respect, Your Honor, the lengthy divorce and all of the things that have gone about all of this have been a financial hardship on me.
Well, I couldn't imagine. I agree.
Yeah. So again, I reached out to them immediately, and there's nothing that I could do in making those payments right away brings it current or fixes the problem that was already there. So I just put that on the back burner so I could handle other financial responsibilities at this time.
Such as what?
Such as what?
Yeah, what other obligations?
Oh, paying off the legal fees and supporting my children.
Okay, well, there's nothing in the judgment regarding paying legal fees first, right? I mean, it's court ordered in this thing that you're supposed to pay this mortgage.
Well, what his legal fees, Ms. Hovecki was threatening to take me back to court if I didn't get that paid to her. I mean, it's coming at me from every angle. But regardless, Your Honor, I apologize.
Well, it's not a matter of apology, it's just a matter of simply following the court order.
And I will make the payments moving forward. That's all I can do.
What are you requesting, sir?
I would like it paid in full. It's ruining my credit. It's on my credit.
Sounds like it's ruining her credit.
It should have been paid. She said, it says right here, the plaintiff will be happy to take over the loan. She says he wanted it. If not, sell the home, add it, and then pay off the windows. Sell the house. I'm trying to move forward with my significant other and my family, and I need to buy a bigger home. And I can't do that because I can't get a loan for my credit. And I got hardships too. I have a house note and legal fees. I'm not complaining. I'm not crying. Everyone has issues, but I'm trying to take care of my stuff legally. And this is the legal way to do it. I can't force her to pay $12,000, but I need my name off the loan in order to move forward with my life.
What is it going to take to get this out of collection?
There's no way to get it out of collection other than to pay in full. And they don't do in-house refinancing, so they told me I would have to get a personal loan or some other way, which I've already taken out personal loans and credit cards.
It's got to be paid.
Yep.
I recently spoke with Foundation 2 months ago, and there was no payment up to then.
Well, she admits, she just started
It's
paying.
not about the payments, that doesn't.
It comes down to the obligation.
Yep.
It's gotta be paid. That's part of the court order.
Also, Your Honor, the house is supposed to be on my
Excuse
name
me,
as
sir.
well,
I'm,
but I can file another motion, sorry. I'm not trying to cut you off, I was just.
so you did, but
If you want.
I've been cutting everyone else.
Since we're
because
here.
No one's listening to my question.
Sorry, Your Honor.
Don't be sorry. You're fine.
For-
What are you going to do regarding payments? Is there some sort of settlement that they would agree to? Ms. Howison?
No, because it was charged off. They don't have the ability to do anything because he allowed it to go to collections.
Well,
That was why I was making a note of that. I know it's passed.
so are you talking with the collection agency?
No, I only talked directly with Foundation Finance.
But they've discharged her, correct?
I mean,
They handed it off to
they're-
us.
They're still accepting payments.
But it went to collection.
Yes, it's in collections. It's been in collections since February 28th of 2022.
What can you make in the form of payments?
I'm paying $150 a month already. But that doesn't get it paid off very quickly. I understand that, Your Honor. I mean, if I can be given a length of time at least to deal with it, I don't know.
How much time are you requesting?
$12,000 is a lot of money.
Oh, I know it is, believe me.
Is there a reasonable standard for this? I don't know.
About 6 months.
Yes.
Any objection to that?
No.
6 months. We'll schedule a date now. If it is paid off and proof is provided, we won't need to have a hearing. If it is not paid off, parties need to appear. We have a date. Now, I'm sorry, I'm severely enforcing the judgment that's been entered.
I understand, Your Honor.
Your Honor, you want me to file a motion for the home loan as well? Because she hasn't done the home loan out of my name either. Or should I file a motion and come back?
I can't tell you what, you can file whatever
I'll file a
motion you think are
motion
appropriate.
and we'll take care of that another day.
September 26th.
Can the parties be available September 26th?
Yes.
Great. 9 a.m.
9 a.m.
9 a.m. it is. We're going to give you notice now. And hopefully by that time, we can have some, hopefully resolution on that issue. I'm glad that you're both looking at the best interest of the children regarding making these dates consistent with each other, contiguous, I should say, connected. And let's move forward. We'll provide notice. That'll conclude the proceedings. 1 DM. This is the defendant's motion regarding what I believe is counseling, amendment of judgment, and orthodontic issues and tax ramifications. Parties are both present. Before the court proceeds in this matter, Ms. Hill, I've tried to read this motion. I can't make any sense of it. It's difficult to read. I have copies. I don't have originals. And I really have no idea what you're asking of the court. Try to figure it out. I did my level best, but it's not making any sense to me. So, and that's not being disrespectful. I just can't read it. So I cannot hear the motion today. I'm going to require you that when you submit further pleadings, because I know that you've done a lot of emailing with court staff, you can email the pleadings typed out so I can read it. I'm having a difficult time understanding this. I mean, the police reports, clearly the court can read those and understand those, but your handwritten stuff is very difficult for the court to read.
I wasn't advised that I could do them individually or type them out to the court. So how do you, I guess my question is, how do you want them done then?
Just if you could type them out in an email and attach it to this, that would be acceptable to the court. Then I'd be able to understand it.
Okay, so you want each individual motion typed and filed, not all on one?
Well, you can put it all on one, but I just need to have an understanding as to what you're asking for, that I can read it clearly. And I don't mean to belabor it, because I'd rather have this resolved and get the parties moving on. I really would. But if I can't read it, I don't want to do something that I didn't understand to begin with. So you can type it out in an email and all the issues, then I can properly read it. Make sure you send a copy to Mr. Coth, and then we'll address it. When do you think you can have that done?
I can get those. Do I still have to submit 4 copies of everything, like the police reports, 4 copies?
No, I don't need the police reports.
Okay.
Those are already here. You can just type it up as what I call an addendum,
Okay.
and submit it to the clerk that way.
Okay.
Okay? So then I'll understand what you're talking about.
That's fine. I can go ahead and take care of that on Monday.
Great. Shall we notice this then? Is it 21st too early? Next week?
Or it's the 14th, I'm sorry.
14th?
I can't, the 14th is,
21st.
that will be fine.
21st work for you, Mr. Coth?
Of what month, Your Honor? Of this month?
March, this month.
It should.
Okay, let's do it that way. And I apologize, it's more and more we are getting pleadings from individuals, and I'm not saying you personally, but there are some pleadings that the court receives that I can't make anything out. This will make it clear to the court we can make a proper decision based on that. You're both free to go.
Thank you, Your Honor.
Now, I do have one question. I'm sorry.
Okay, stay on the record. Go ahead.
The dental copies of the contracts and things that I brought, as well as the flash drive evidence for the 1 police report. Do you want me to bring those at that time or leave them here today while I'm at the courthouse?
Bring them at the next hearing. You're all set. Thank you both. Off the record. This is the defendant's motion. We previously had this heard approximately a month ago. The court had requested the defendant to provide a more legible copy, which she did, and I appreciate that. The court does. The court has read the motion. Will both parties please raise their right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Ms. Hill, you may proceed, and please stand when you address the court.
Did you say stand?
Yes, please.
The motion that I had sent to you and revised was regarding requesting that the court order anger management, substance abuse counseling, and a mental health evaluation for Mr. Coth due to the incidences that have transpired during his parenting time. I've had 4 welfare checks during the time that they were in his presence for visitation, and the most recent one resulting in evidence of threats that he had made in front of the children that my daughter recorded and sent to me because they were so distraught. She called me after she had sent the text with the recording from outside of the home, where you could hear the wind blowing and the cars going by, letting me know that he had been drinking all day, had come in at the time he was screaming at them, throwing plates in the sink and screaming things. I am not Steve. I will not do everything for you.
So these welfare checks were police calls?
Yes, and I provided police reports in with my previous motion.
Okay, but that's hearsay. I need to have the police officer.
So the report is not valid, even though it was written by the police officer.
Well, it's still hearsay under the rules of evidence.
Okay, what about the flash drive evidence of the recordings that I was told I could present? Because they are recordings of what he said in front of the children and are beneficial for you to get the full impact of what they're being exposed to during these visits.
Did you provide those to Mr. Coth?
You told me that I couldn't do it until today's court date. I had all 4 of them.
Do you have them now?
Yes, I do.
Okay, you want to have them review them? Then we'll recall this matter momentarily.
Well, the flash drive he would have to play.
Yeah, I don't know how to accomplish that. Do you have a computer or something?
No, I don't, Your Honor.
But I do have one for each of you, and I was told by the clerk's office that was the only way to present evidence was on a flash drive.
Right, but before the court even attempts to admit it, the other party has the opportunity to review it. Okay. I have to do that.
And that's why at the last court visit, I asked if you wanted me to hand those out, so you guys would have a chance to preview them before the next court visit.
I can't do that unless it's admitted. The court cannot take information from one party without the other party having an opportunity to hear it, number one. But number two, it has to be admitted in the court proceeding first, then the court reviews it. That's the rules of evidence.
I did have it present at the last meeting, if that's what you're speaking of, but you did not want me to submit any of that, and that's
right. Submit it to the court, but you can share it with the other party so that he can review it.
I was not told that when I was here.
Okay, well, I can't provide legal advice. I'm just telling you the rules of evidence that apply. But I did read your motion, and I clearly understand where you're coming from. And I'd like to also hear regarding the taxes and orthodontic issues.
You still want me to continue to stand my present?
Yes, please.
Okay.
Yeah, I've been a little lax on that, and when you're testifying, that's one thing, but if you're presenting the motion, I require the parties to stand.
So then the first motion with the anger management and the substance abuse conflict, it's not even going to be relevant today, is what you're saying?
No, I'm not saying that at all.
Okay, just so I'm clear. Okay, and as far as the orthodontic situation, I have been trying for 2 years to get Mr. Coates to comply with the orthodontic requirements that daughter L needs for her, I guess basically congenital problem, because she was born with these issues in her mouth.
And he won't sign the contract.
No, he will not sign the contract. I also submitted all of the information to Denise Granovich, if I'm pronouncing her name correctly. She sent all of the findings to myself and Mr. Coates, as well as I sent documents with the contracts, the letter from the orthodontist stating the medical history and the necessity for them, as well as a contract breakdown, insurance coverage, monthly payment to deposit between both of us. His response back to me was, that is what child support is for, and I have insurance. Even though these things were stated in the letters that they go above and beyond the insurance coverage, because yes, he does have dental coverage, but it does not cover the initial deposit. It does not cover the monthly fees. He stated he knew nothing regarding Lily having to go to this dentist, yet the letter stated she had been a patient there long before we even were divorced. So he was knowledgeable of the fact that these were issues. She was born with congenital problems with her teeth and jaw, and the only way to correct these is to have the braces put in place in hopes to bring those other teeth forward, because there are no adult teeth behind them, which would leave her with the only other option of having to have implants, which they won't do until she's done growing, and those would be around $15,000.
Tell me about the taxes.
With the taxes, that original tax judgment was based on in our divorce, was based on the original custodial and parenting time agreement. Custody has changed with
By
child
stipulation,
C.
he agreed to it.
Yep, he agreed to it. And parenting time, which originally in the first divorce decree was week on, week off, and over breaks and holidays, that has changed as well. He usually declines any breaks when they are offered. He sees the children every other weekend, and that totals to be about 72 days a year if he doesn't forfeit any weekends that they are sick, or make up a weekend if he forfeits one, giving the kids privilege to go to a birthday party or a special event. The children are under our care 293 days a year. So I'm asking that when he wanted to do the every other tax year rotation after child G is no longer able to be claimed on his tax form, which would be this year, he could claim him, I'm sorry, pardon me. Next year, he can claim him for half of the year because she graduates, and child Q for the full year. So he wanted to claim one of the girls, which we typically have done. He does the boys, I do the girls all along. What I'm asking is for that motion to be amended or modified due to the factors of custodial and parenting time changes, and the fact that unless it's court-ordered child support, all other parental responsibilities and obligations rest on myself and my husband.
Okay. Back to the anger management, substance abuse, mental health, all of that. That was the basis for the one child's custody to be changed, correct?
That was the start of it, yes.
Okay. Why wasn't that brought up with all the children rather than just one?
I had brought that up in previous, I had tried to get a restraining order after one of them because during one of those,
a PPO you're talking about?
Pardon?
A PPO, right?
Yes.
Okay, but what I'm asking is, the same issues you were alleging regarding Mr. Cove ended up with the one child's custody being changed by agreement,
Yes,
actually.
by agreement, yes.
But why weren't the other children included in that motion?
My lawyer only put child C in there because she felt that that was the sole focus of that court date, and she picked and choose what she thought that you would hear at the time.
Okay.
And I'm not sure, I know you see a lot of kids, you see a lot of things, but we had also come for an in-chambers meeting with you, just the children.
Oh, I recall.
Yes. And
Absolutely.
where
Met
they,
all the children.
yeah, where they spoke about
Except
what,
G.
yes, where they spoke about what situations are both during our marriage and after. These other situations have escalated through this period. And the last one is what brought me to the point where I believe that by ordering these things for him, it will make him a better parent and deal with whatever issues he has, be it substance abuse, the drinking. I don't care if he drinks on his own time, but drinking to the point of where it escalated that day, it's not acceptable. And if my older son, G, was not there, the police officer was going to have myself and my husband come and obtain the kids because he didn't feel that it was a safe environment.
Thank you. Mr. Cole, your response.
Your Honor, basically that all of this has started when we had the incident with my oldest daughter, C. She got it for domestic violence. She was after her driver's training money, which you told us ourselves, don't discuss any financial situations among the children. And I told her, I said, see, this is not your discussion to be heard. She says, yes, it is because I'm involved. I says, no, it's not. Well, anyway, she took my phone, went into the bedroom, and I followed her. And according to what Ms. Hill has on here, that I pinned her up against the wall and the dresser. No, I was at least 3 feet away from her, raising my voice, showing no discipline, but just raising my voice, saying, see, give me my phone. There she says, I'm going to sell it. Well, then go ahead and sell it. That's so go get a new one. This we came back out of the bedroom in the living room. She said something to me again about the financial situation. I turned around and she punched me. I says, what did you just up and do? She did it again. That's when I called 911, and that's when things started to dispute between me and Miss Hill all the time.
Were you charged with domestic assault?
Excuse me?
Yes.
No. It also states there that Miss Hill said there that I spit on my daughter and pulled her hair. Now, was that a form of domestic violence if I would have did it? In my book, yes. Was I arrested? No, because I did not lay a hand on her, Your Honor, nor would I. And every police report that she has written up has to do with heavy intoxication. It's not true, Your Honor. When my kids are there with me, I'm there for them. I don't endanger nobody's life. But in November of last year, it was through a 5-6 hour span. I got home from work in the morning. My house was blowing up. Dishes everywhere, countertops a mess, wrappers from ice cream on the stands, the bathroom a mess. I said, hey, can somebody help me, please? I did what I had to do, got the house all cleaned up, and I said to my youngest daughter, Elle, I'm going to go lay down for a few hours. I'm tired. You guys can have dinner, whatever. There's food in the cupboard. Help yourself. But it says, please clean your mess up. I got up roughly probably 1 o'clock. Went out into the kitchen. People, are you serious? You're 14 years old. You're 9 years old. You know where the trash can is. You know where the soap is for the dishes. Please do them for Dad. And there was a football game on, Your Honor, that's I wanted to watch. It was the Lions. I mean, if I'm going to have a beer, which is very, very rare, when my children are there, I go out in the garage so they don't see me. But through that 5-6 hour span, the officers even asked me, how many beers did you have, Mr. Coates? I said, 3, maybe 4 at the most in a 6 hour span. So I said, I know what I'm doing. And I did say to my children, I got my rules at my house. We're going to follow them. I don't care what you do at your mother's or Steve's. My house, let's get it cleaned up. So it says, whatever you want to do at your parents', don't do it here. And that's all I said, Your Honor. Yes, I did break a dish. I was doing dishes. I had a sink full of clean dishes over on the one side. I was doing plates. I washed the one plate. I went to move it over and it hit the faucet and broke. I don't break my dishes on purpose because I don't have that many dishes anyways. So why would I break a dish on purpose? But everything that she states in here has to do with alcohol. When we had that incident with my daughter, C, me and the officer were out in my garage. And I said to him, I says, if you believe me, and if you don't, I said, I'll take the portable breathalyzer. As he looked at me, he said, Mr. Cole.
Can't go to what the officer said.
And he says, no, I don't have no reason.
Again, that's hearsay. I can't consider that. But, okay.
But if everything has to do with alcohol, I do not have an alcohol problem, Your Honor. I do not have an anger management problem. My anger is coming here so many times, it's frustrating to me. I want to live my life the way I want to, not let somebody else run it for me for the last 28 years, and that's what she's trying to do. Right? She is trying to get me to sign off custody on my other 2 children. And I have no further questions or answers, Your Honor.
Rebuttal argument.
In response to that, the police report clearly indicated
Can
that.
you talk about what's in the police
Okay.
report? 'Cause I'm not considering what the officer said to him either.
Okay. If you were to listen to the flash drive, you could hear the effects of what the children are exposed to. I understand getting upset if things are left around the house. That's part of parenting. Kids are learning. Yes, they make messes. But what is not okay is you don't throw dishes and you don't break them where something could fly into one of the kids' faces and scream about either parent. And it's been said before with one of the police reports I submitted that you want that I hate your stepfather and I wish that the mother.
Okay, again, that I need to get that from the officer.
Okay. But I do have that recorded on these recordings is what I'm trying to say. So to get the full impact, you would have to listen to it. No, I don't want him to not ever see his children, but by requesting this, I want him to have the tools to learn to deal with anger that he has either from our marriage, from our parenting together. I want him to be the best parent that he can be and learn how to handle whatever issue he may have, be it his drinking when the kids are there, be it his anger when the kids are there. Because what this is doing is this is affecting them both mentally and physically and is very detrimental for them in the long run. They don't want to go to parental visits because they don't know the unpredictability of what's going to happen when they do. They're scared. If you were to hear this, you would see why that they are scared. I don't want to take the kids away from him, but I do want him to have the necessary tools, training, or therapy to be the best version of himself that he can be, because his actions mold what type of emotions those kids hold and feel inside, not only about themselves, but about what they feel when they go there. A parent's place when they go for a visit should not be a place of trauma, should not be a place of fear. It should be a safe place, and that's how they should feel when they are with him. And I don't feel at this time that he has those tools to do the things that he needs to, so they do feel that way at their parental visits. That's why I'm requesting that.
Great, thank you. Don't need to hear anymore. It's going to work in reverse order regarding the issue of the orthodontics. As far as the court's concerned, that is part of the original judgment in this case regarding medical expenses and how that is supposed to work. Father didn't make any mention regarding the contract. And, you know, that's part of legal custody. The problem, though, is when it comes to legal custody and the parties are in constant dispute over legal custody, there could be a point in time where the court just says, you know what, only one parent has legal custody. That's where this may be going. But at this point, we've done this in a previous case, and I'm going to do it in this case as well. Mom, if he doesn't want to sign the contract and you wish to proceed, and it's obviously for necessity purposes based upon what you stated, and I'm accepting your word, then we'll get it the other way. That is, you make the payments, submit them to the front of the court, they'll be taken right out of his check.
Your Honor, I do not have a problem at all with that.
You want to sign the contract?
I'm going to sign the contract, but is what's got me angry and a little bit upset I never knew anything about these dentist appointments. I was never called for an invitation at all.
Okay, we then either, I'll require you within, do you have the contract today?
Yes, I wrote a copy for everybody.
Excellent. Want to hand him one so he can sign?
His was sent to him when I had to resubmit the new email, and I gave that to Alicia. He should have received that.
Do you have it, sir?
No, I didn't bring,
Sign that.
not bring that with me. Your Honor.
Sign that. Then that'll take care of that issue regarding the
I do have an extra copy that I had for the clerk's office. He can use that. I have one.
Doesn't matter, whatever works for the orthodontist is fine with the court, as long as that. Second issue, regarding the issue of taxes, there was a stipulation regarding that. I understand the custodial environment has changed by Mr. Coates' own stipulation. He agreed to it, but that doesn't change the agreement. That motion is respectfully denied. Relative to anger management, substance abuse, mental health, and all of that. The court takes judicial notice that the parties have a volatile relationship, have for years. And I wouldn't say years. I think when the divorce was entered, the court took the proofs, and to be honest, when the parties were completely separated, and then Ms. Hill meets another individual, they get married. PPO in Tuscola, we have a PPO in Huron. The volatility between the parties, amongst the parties, including Ms. Hill's husband, is off the chart. And so the volatility has been there for years amongst all the parties. And I don't need to hear the audio. I can hear it from the parties. Just the animosity and the just sheer anger these parties have between the two of them. And it's unfortunate because it rubs off on the children. So it appears Ms. Hill's argument focuses on the consumption of alcohol. And what the court is going to do, rather than these tools, the court is going to make it very simple. 8 hours prior to and throughout the entire parenting time, Mr. Cope is not to consume alcohol of any type, no controlled substances, unless duly prescribed at any time. I'm not saying he is. However, by ordering that, and if it's discovered and proven in the court that that condition is being violated, then hell hath no fury, as far as the court's concerned. No more alcohol at all. I don't care if it's 4 beers during the Lions game, that doesn't make a difference. 0. So, all other motions, though, will be denied except for the fact that no alcohol. The taxes we've addressed, the orthodontics we have addressed as well. And I can understand the frustration, Mr. Cove, of having to come back into court, but the tempers have to come down. Also, it is troubling to the court. And like I said, I spoke to all the children. You folks are blessed to have these children. But it appears that the children are getting in the middle as well. And as a result of them being in the middle, where they're actually allegedly recording something that's going on in the house. Mr. Cove, if it is true that you're making these statements, it doesn't serve any purpose. All it does is drive a wedge further into these children. And then they're going to go to mom's side and say, Mom, guess what's going on? Guess what's going on? And we come back into court.
And that's exactly what's being done, Your Honor.
Well, it's done both ways.
Mm-hmm.
It's done both ways, and it has to stop. When you have the children, very simply, you have the children, you be the good father you say you are, you take care of those children, you provide them guidance, support, everything you need to make them better people. With no alcohol involved, I think that's going to go a long way. On the flip side, when mom is bombarded with all of this, it just brings up that animosity more and more and more. Ruling on all issues. That's how we're proceeding now. The orthodontic bill, has that been signed? You have a copy for Sydney?
It's right here. He would need to sign and date it, and then he would need to take care of his own deposit through the orthodontist where they provided a number, as well as his half of the monthly payment would have to go directly to the orthodontist.
Okay, and regarding that, if he doesn't pay it and you pay it, submit that bill in front of the court and they will gladly make sure you get reimbursed for it.
Can I ask, will it be at 7% reimbursement or the entire amount?
That's gonna be through the front of the court.
Ortho is like any other medical expense, it's shared for the percentages of the support order at the time that those receipts are submitted. Once that contract is signed though, please turn a copy into our office so that we have our records.
Please. So by doing that, they have the records and they can enforce it.
I'll give him this, or he can reach out to them. They will send him a DocuSign for him to sign his portion, or he can make his deposit and make his half of the monthly payment as well.
You still use AppClose, correct?
Yes, I have AppClose on my phone, correct?
Okay, what I would do, give him the documentation that he needs. I would provide that information in the AppClose instruction so that he clearly understands what that is, and then you've done your due diligence.
My next question is, before you roll on the tax years, when you have us rotating, would I be the odd or the even years, just so I know that for my own tax purposes?
Whatever the order states. I don't know what the order states.
That's I'm on the odd years, Your Honor.
Whatever it may be.
So this
The
is
order,
25, so
you'll
next-
have to review the order. And I also may add, regarding this issue of the alcohol, anger management, all of that, that was going on regarding, frankly, all the children, but the primary focus was the eldest child. And by the lawyer strategy and just focusing on one, it should have been addressed all at once. But that's not my call. That's what the attorney did. We're done. Good luck to both.
Do you want your copies of these documents as well?
Don't need those because he's signed. Thank you.
So is this gonna be my contract then, Your Honor, that I can keep, or does this gotta be turned into the front of the court? Because I want to call this orthodontist myself, and I want to find out.
Call the
what's going on.
orthodontist yourself and follow through with that. But if you have a question regarding, send an AppClose message to Ms. Hill.
So I'm gonna get on the phone today, and I'm gonna call the orthodontist, and I'm gonna set up everything it is I need to do with a payment, and it ain't gonna go through the front of the court. I'll just send it right to the orthodontist.
Well, however it needs to be done to make sure that those obligations are taken care of. 6716 PM. This is show cause regarding Mr. Babashewski, regarding support. Parties are present. Would you both please raise your right hands?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
I do. Thank you. Mr. Holdwick, what's the status of this matter, please?
Your Honor, this was brought before the court for a show cause regarding non-payment of support. This case is a little different, as the court is aware. We do receive withholding orders for Mr. Babashewski. However, it is the monthly withholdings are only about half amount of what the support order states. The file in this case says Mr. Babashewski has been instructed he had to make additional payments with his other income that is not garnishable to try to meet that obligation.
What is the other employment? Okay.
And it looks like on the account, Your Honor, we've been receiving about $546 a month on a monthly obligation of $1,095. Back in June, the court had ordered, I believe, a bond from Mr. Babashewski in about $7,000, a little over, to secure payments for future monthly obligations. That was posted in June, and then since then there have not been any additional payments besides the disability withholding. So the motion was brought back before the court. This has been an ongoing issue. Mr. Babashewski reached out to me, I believe, yesterday, stating that the parties have worked out some type of an agreement or are on the same page of payments moving forward. I'm not 100% sure, and it was stated that could be stated on the record today. So I'll defer to the parties on that.
All right, but is the bond still out there?
The bond has been posted. It was paid and posted on the account.
The bond was secured for payment of future support payments. However, Mr. Babashewski authorized the release and application of the full bond amount for
Oh, so it's already been applied. Okay,
And
got it.
currently the case, Your Honor, has an arrears of $14,919.
Is the AG off? AG's office been notified on it?
I believe, they have been in the past, but my understanding is, they are not authorizing or following through as monthly payments are coming in.
I see. Okay. Pretty big amount. Pardon me?
Any other-
I also made a payment today, Your Honor.
Yeah, I'm sorry. There was I believe, a $600 payment that was made this morning before.
Okay. Okay. Well, we still have huge arrearage here. Mr. Holdwick stated, though, Mr. Babashevsky, that there may be some agreement between you and Ms. Kettle. Is that correct? Okay. What do you believe the agreement to be?
Well, I went through another divorce. I had a number of things that was divided, if you will. I talked to Ms. Kettle about it. We've been on the same page for several months. Now that everything's taken care of, we have an agreement that everything within the first 7 days of the month. Paid full obligation.
Your arrearage?
Well, the arrears, but it would be the payment plus additional to knock down the arrears.
So 1095 and more money to be paid?
Additional, yes, sir.
How much are you proposing per month?
At least a couple hundred every other week.
So for the month, though, you're talking at, when you say couple hundred,
300-400, I would assume would be something that's doable, Your Honor.
$300 to $400. So it'd be at least $1395 or $1495 per month.
Yes.
When would you start making that payment?
Beginning of next month. I could probably, within another 2 weeks, make another payment. Start knocking it down faster. That way the arrearages aren't existent.
Just for the court's information, so far for the month of March, we received $556.50. With the addition of the $600 that was paid today, his monthly obligation will be met.
Satisfied.
So any further payments this month will just go straight to the arrears.
Perfect. Well, that's good for March.
I'm still going to make an additional, though, Your Honor. You know,
I appreciate that because it's for the child. That's what it all comes
yeah,
down.
we've been on the same page about extracurriculars. I've put money to her as well, paying for extracurriculars and clothing and whatnot.
Okay. Ms. Kettle, do you agree with this?
I just want to make sure that we have a date, like he makes his normal payment like first of the month and like 2 weeks later, he makes the additional payment. If we can get something a little concrete, that way he can follow that, I think that would be doable.
What do you say to that, sir?
I'm fine with that.
So half of it,
By the 14th, the second one needs to be made, I guess? Does that sound fair?
and the second at the end of the month?
Sure, that sounds fair to me.
I'm asking, is that what you're proposing?
Yeah, that's fine, Your Honor.
So the midpoint of each month, and then by the end of the month, we would have at least $1395 in support.
Right. Yeah, that's correct.
Does that work for you, Miss?
It does. Because of the history, what do we do if that does not get met? We just meet back here again?
You can let the friend of the court know and they can show cause the matter.
If the court approves, we could do a status conference on Friday, 90 days out to see for compliance.
Do a review in 90 days.
Absolutely.
All right. So both parties agree with this?
Yeah.
Sure. Well, look, you good with this?
So just so I'm clear, Your Honor, it's the already withholding order of the 556 that comes at the beginning of the month. And then Mr. Babashevsky would have until the 14th to make an additional payment. And then by the end of the month, another additional payment?
Yes.
I'm understanding this?
Yes. So whatever the withholding is, and then you add to that by the 14th, at least half of the support obligation. And at the end of the month, the rest of the half, which would total at least $1395. That's the total amount per month that he's going to be paying at a minimum, $1395. His current obligation's $1095. He said $300 to $400 per month.
And the first day of the month, we already received over half the support obligation with the current withholding.
Okay.
So in addition, you just want half of the $1395 by the mid-month?
Yes.
Okay.
Yes. Fair?
Yes, sir. Would it help if I call when I make or provide a copy to Ms. Schultz or Mr. Holbert?
I think they'll see it in the system. Do you wish to?
Normally, when the payments are made directly through the state disbursement unit, we can usually see that information within 48 hours. if you want to email us and let us know you posted it, we can keep an eye on the account to make sure it comes through.
All good? So, Miss, do you agree that things have been better regarding communication?
Communication between the two of us has been great since the last few months, yeah.
I love to hear it. That's great news. Let's keep it up. We'll see you in 90 days. You'll set that up, Mr. Holdway?
Yes, sir.
Yes. Okay. You're all free to go. Motion regarding parenting time through custody. We called this case earlier this morning. Ms. Gage was present. She's the moving party. The court called Mr. Hockmuth. It was, I can't remember what time I called the matter, but it was during the time frame here between 9 and 10:30. It's 10:34 now. The defendant is not present. He is not checked in to the Zoom application as well. There's a certificate of mailing in the file. The certificate of mailing is executed by Alicia Thomas, Family Court Clerk, Huron County Clerk's Office, February 5, 2025, to Mr. Hockmuth at an Owendale address. And he has failed to appear. And as a result of that, at this point, as proper notice has been received or been provided to the defendant, we are going to proceed without him being here. Ms. Gage, please raise your right hand.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Thank you. Please state your name for the record.
Angel Gage?
Ms. Gage, I read your motion. This is regarding custody and parenting time, correct?
Yes.
What is the current arrangement right now?
We found it off.
All right. And in your motion, you're alleging that that has not been working. What's been going on?
Mr. Hockmuth is on second shift currently. And he is left home every night from the time she gets out of school until he returns home, sometimes as late as 1 a.m. if he has to work overtime. And he has also been working the weekends, so she is home at night on the weekends as well.
How old is the child?
11. I do the best I can when I can to go check on her to make sure she is safe, because she does not have a phone, because she proved herself unable to have the internet. So I have taken the phone away.
Children can be children.
Yes. She is not allowed to lock the door to protect herself. When I have left his house, because he has no problem with me going to his house when he's not there to check on her. When I did lock the door, I got a message from him that told me not to lock the door, because I don't know if he doesn't have a key or if he just doesn't bring it. There are numerous women in and out of the house. Sometimes as often as one will stay the night and the next day another one is there. He takes them to, and what he does with his personal life is fine. My concern is her safety being taken to other people's houses, or currently he has some lady there from out of state that I don't know how long he has known, but she is currently staying there this week.
Child's initial again is M, correct?
E.
E. Who is Mads?
Madison, our now adult daughter. I apologize.
Okay. Because you
I
attached.
apologize. Yes, those were, I was hoping that she could attend with me to go over what those messages are about, but she has left the state.
You have, I believe you placed in your pleadings that the child on dad's time is not getting to school or getting pulled out of school.
Yes.
How often is this occurring?
It depends. I have dates when she has been, on December 16th, she was supposed to return from my parenting time. She did not. And at that time, Madison was living in the state and was at work. And I had to take her and drop her back off at Tony's house. And that is when I found out that he did not go to school and had been there babysitting.
Babysitting who?
Her younger siblings that are him and his estranged wife's
Okay.
from another relationship.
At your home, excuse me, at your home, are you the only individual in the home other than your child?
No, my husband is there as well.
So the child's not left alone? Is a child of sufficient age, in your opinion, to be alone?
No.
Why do you say that?
She is not able to defend herself in case of, in my home, I apologize, sir. Would you mean in my home or?
In his home?
No.
Or even your home? Both?
I do not leave her alone unless it's for a short period of time. Plus I live next to my parents who she goes over there if I'm not home.
You live on the same street though as father, correct?
I do not.
No?
He lives in town of Owendale and I live out on Seaton Road.
Your pleadings that you filed indicates 7th
That
Street,
is his address.
35. Yours is 4518.
Yes. See.
You have 4518 7th.
Oh, no. I apologize.
So that's not your address?
No, it is
The
45.
parenting time shows 7th Street. But then as I look, the custody motion shows C.
Yes, I apologize. That is incorrect.
Okay. How far apart do you live from each other?
I think it is, I think 7 miles.
7 miles?
Yes.
How old are the children you're claiming your daughter is watching?
3 and 5. Actually, I believe 6 now. I believe she just had a birthday.
Okay. The problem is Mr. Hockmuth is not here, and I'm not sure why he's not here. And so what the court will do at this point well, what is it, before I make a decision, what is the proper cause or change in circumstance you believe the court should review the custody factors?
That she is left alone for numerous hours by herself. Well, left alone by herself for numerous hours after school. The amount of women that are in and out of the house. The fact that she is pulled from school to babysit and or has been pulled out of school or kept from school as a punishment because one of the nights that he had come home from work, she was not there. And he had called me to see if I had her, and I told him no. That I had seen her earlier in the day and that I was not sure where she was. I told him to go check around town. He told me he would not. And then she did end up returning home, but as punishment, she was kept from school to clean her room for that day.
Okay, this is what the court is going to do. I really need to have Mr. Hockmuth here, and it's his fault that he's not here because it appears proper notice has been provided. If he's indeed working second shift, there'd be no reason at 10:42 he cannot be here at the courthouse. So on an interim basis, the court preserves the motions that you filed, custody and parenting time. The court is going to show cause the defendant, sua sponte, why he, and to explain why he failed to appear for today's hearing. And we'll set a date for that. And we'll see what happens with that. In the interim, though, I'm going to order 2 things. Number 1, the child is not to be taken out of school during either parent's custodial time unless there's a doctor's slip explaining why the child cannot be in school. So if it's, well, you're supposed to babysit so-and-so. No, we need a doctor's slip. That's number 1. So secondarily to that, child's how old again? 11?
Yeah.
The court will also order that both parents on an interim basis shall not leave the child alone unless there's a responsible adult with the child. So that applies to you as well. You understand that? I'm sorry, I didn't hear you.
Yes, Your Honor.
Okay, thank you. I'm applying to both parties because what's good for the goose is good for the gander. If the child shouldn't be left alone without dad being there, same applies with you. Now, if your spouse is there, great. That's appropriate. But I'm going to order that on an interim basis. We'll set a show cause date, and then we'll address your motions at that time. So we have assurances at this point. Number one, the child will not be left alone on either parent's time. And number two, the child's not going to be pulled out of school unless there's a doctor's slip explaining why. So we have at least a stopgap measure until we have the. Do you have any questions?
No.
122 DM, you're free to go. This is a show cause hearing filed against Ms. Montgomery, alleging violation of. Well, I'll have the front of the court address that. Miss, would you please raise your right hand?
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God. Yes.
Thank you. Miss, your name is Cassandra Rose Montgomery?
Yes, Your Honor.
All right. From the front of the court, please. Ms. Schultz.
Your Honor, the parties last appeared before the court on January 6th. At that time, the court had already ordered the friend of the court to conduct an investigation into the issues of custody and parenting time. However, when the parties last appeared, neither party had submitted any documentation for consideration in the investigation. The court had subsequently ordered that they must complete their questionnaires and turn them into the friend of the court office by no later than January 10th at 4 p.m. Mr. Wolfos did submit his documentation. He is the moving party on the underlying motion. However, Ms. Montgomery did not turn in any documentation. It is my and so the show cause was filed, the matter set for hearing today. It's my understanding that the questionnaire was submitted this
No later than January 10th. What is the interim order regarding parenting?
On an interim basis, the minor child A, dad was granted physical custody, and Ms. Montgomery has parenting time 2 days per week. There is an underlying companion child as well.
Ms. Montgomery, why did you not submit the documentation by January 10th?
I moved to Macomb County, Your Honor, and I didn't have a way up here by the time that I had emailed the one paper that Ann had asked me to email her that copy, and then I did mail the rest, but it got returned to my brother-in-law's house, the one 5 River Road in Mount Clemens, where I was residing prior to getting my own house. It did get sent back there, so when I came to court to get Freya back, F, my other daughter, on February 21st, I did get another copy because they had said that they did not receive it.
Unfortunately, I don't find that as a proper excuse. When the court says January 10 at 4 p.m., it has to be filed by January 10. The reason for that is this child's in limbo. This child is in limbo, and the court has to make a decision based upon not only hearing testimony, hearing evidence, or seeing evidence, but also a recommendation from the friend of the court. And I've made it very clear at the previous hearing on January 7th that you needed to submit the documentation. You failed to do so. As a result, the court is going to continue the current order regarding parenting time in this matter, and I'm setting aside the referral for a friend of the court recommendation. You have to follow the rules. Prior orders will remain in effect relative to that issue. Ms. Schultz, do you have anything else? So again, if you want to file a motion to address parenting time or custody, you can do so, but I'm putting the stop to this because I didn't get your documentation in time.
Absolutely.
This time and date set for show cause regarding alleged contempt proceedings against Ms. Mausoff filed by Mr. Tulaski. The parties are present. Would you both please raise your right hands?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, thank you. Before we proceed in this matter, again, I'm just cautioning both parties, please don't mention the child's name. Initials are appropriate, but please don't mention the child's name. And let's hear from the friend of the court. Mr. Holdwick.
Your Honor, currently the parties share joint legal and physical custody. My understanding is that the defendant has alternating weekends of parenting time during the school year from Wednesdays after school, or 3 if there is no school, until Monday morning when school begins, or 10 o'clock if there is no school. The front of the court had received, I guess let me back up here. The front of the court office on January 17th received a phone call from Ms. Mausoff informing that she would pick the minor child up from school. There have been some issues of the child going to Mr. Tulaski's. She was informed by the front of the court office that any violation of the court order could result in enforcement if we were to receive a written complaint for denied parenting time. and that we must enforce the court order as it's currently written. She stated that she did understand if there were safety concerns or well-being, she could contact protective services. Also, upon that conversation with the front of the court office, she was emailed a parenting time motion, fee waiver, and filing instructions. And if she wished to file a motion in the court, she could do so. As stated, that was on January 17th. After that phone call to the front of the court office, the front of the court office did receive 2 denied parenting time complaints from Mr. Tulaski, dated January 30th was one. Both of them were January 30th for 2 separate weekends. So the show cause was scheduled for an alleged violation of denied parenting time for the weekends of January 17th and January 30th, as well as not communicating an emergency with Mr. Tulaski involving the child.
Okay, before you have a seat, Mr. Holdwick. So when this phone call was received on January 17th, are you stating that Ms. Mousoff stated that she was taking the child or picking up the child?
My understanding is that she had concerns sending the child for parenting time. She picked the child up from school.
And that's presuming obviously it was dad's time on the 17th.
I would, based off of the complaint, that's what I would guess as well, or assume as well, based off of the order and the complaint.
Have you heard anything from Child Protective Services or anything relative to any safety concerns?
Review this, Your Honor. I'm not aware of any protective services involvement. Yeah, and Ms. Schultz is confirming that we're not aware that we've received any requests for information from protective services.
And the reason I asked the question, and either you or Ms. Schultz can correct me, but if there's some serious emergency issue regarding a child going to another parent and Child Protective Services gets involved, isn't it true that on when you have significant matters like that, most times Child Protective Services will contact the front of the court office?
They will contact the front of the court office. Any investigation, they'll contact us.
Any
requesting
okay.
What court orders exist or copies of them. Serious inquiries, they will contact us and speak with one of us to state concerns or maybe an interim arrangement, safety plan, things of that nature. Does not change the court order if a written complaint is brought based off of that, but they do contact us if there are significant issues.
And as you stated, there's been no contact.
To our knowledge, we've not been contacted. Correct.
Either situation, if they're looking for parenting time orders or for emergency.
Correct.
Okay, thank you. Pulaski, what's going on here, sir?
On January 17th, Your Honor, there was a tournament, a hockey tournament, and it was in Notre Dame, Indiana. The Cherish had asked me on January 5th if Ethan could be registered to go, and I did tell her that we had plans, or I had a birthday party planned for my younger son, T, and that he would not be going. She's harassed me about letting E go and putting E in the middle, having him call me, try to negotiate something with me. But I was adamant that we had a birthday party planned for T and that wasn't possible.
That was your time, correct?
Yes, sir.
And correct me if I'm wrong, but didn't we address this hockey issue before?
Yes, sir, Your Honor.
And I know it may sound cold to individuals who may not have to deal with custody or parenting time orders. A child may have an interest in a particular field. It could be 4-H, it could be farming, it could be a job, it could be sports, it could be anything like that. But when the child's with the other parent during that parent's either custodial or parenting time, that parent controls what happens.
Yes, sir, Your Honor.
And that's what you're relying upon here, correct?
Yes, sir.
So you're alleging not only, did you see the child at all on the weekend of the 17th?
I did have him the 15th and 16th. And then when I went to pick him up pick him up.
Were you supposed to have him the 15th and 16th?
Yes, sir, Your Honor.
Okay. Oh, pick him up from school.
Yes, sir.
And did you see the child the weekend you're supposed to have the child?
No, sir, Your Honor. I had T, but not E.
Okay. What about the 30th?
The 30th, I supplied the school with the divorce decree and then highlighted all my days. And E was supposed to go to the office because I was afraid of this happening again. But when I went to the school to get E on the 30th, he had gone out the back of the school. And then Cherish had taken custody of him then.
So you're saying that the child was with mother that weekend as well?
Well, that Wednesday on the 30th, E was with her. I did, however, pick T up. And then on the 31st, I had my daughter pick E up 15 minutes prior to him being dismissed. So that couldn't happen again because she had planned on taking E on the 31st too.
31st would have been a Thursday or Friday?
Thursday, I believe, Your Honor.
Friday. Okay. So for the second weekend, you're not alleging that you missed the whole weekend. How many days did you claim?
1 day, Your Honor.
1 day. I saw Mr. Holbrook spring up all of a sudden.
Yeah, just for the record, Your Honor, looking at the complaints and looking at the calendar, regarding child E, it's between the 2 weekends, I believe it's a total of 4 overnight.
Total of 4? Okay. Anything else you want to tell me before I go to?
No, sir, Your Honor.
Okay, thank you. All right, so Ms. Mousoff, how do you respond to this?
Contrary to the allegations that Brian is making, my actions have always been for the best interest of both children. The last time we were in court was October 4th, and I explained to everybody then that Ethan's mental health, he was not in a good, he was not in a good place. Emotional breakdowns, he started doing poorly in school, and from October to January, it had gotten worse. He talked about hurting himself, feeling trapped when he was at his dad's, not wanting to live anymore.
So with that in mind, if that is true, then why did you not file a motion for change of custody and or parenting time?
Well, I tried therapy first. And when I tried to talk to Brian about it, and I didn't get anywhere then. And so as far as that weekend goes, on Monday, Ethan took it upon himself to call Brian, and
we're not going to go on what the child said. I'm talking about your actions.
Okay.
Let's just talk about your actions.
Okay.
So you're alleging mental health concerns.
Yes.
Okay. So the proper way of doing that is to file a motion with the court and not defy court orders. You defied a court order. What's attached to this is the app close information, which indicates E called me from, this is from you, E called me from school, pleaded for me to pick him up. He begged you to let him go, referring to this hockey tournament. So, and then you put in mental health part here, but it was his dad's time though, right?
Which has since been made up. That weekend was made up.
That's not true, Your Honor.
It is true.
Wait a second. Wait a second. We'll address that in a moment. We'll address it in a moment. But you read, Miss, the notice that lists the possible consequences for violation of court orders?
On that day, I was stuck.
No, I'm asking you, when you received your notice from the friend of the court's office regarding today's show cause, did you review that?
I did.
Okay. And did you review the possible consequences if you're found in contempt?
I did.
Okay. Well, I'm finding you in contempt because a couple things. Number one, the court order clearly establishes what the parenting time, custodial time schedule is. That's one. Number two, when it comes to serious issues, and you know, I'm always going to have one parent say, well, there's a serious mental health issue. The other one's going to say, no, that's not the case. That's what I'm presuming here. There's nothing from a psychologist, psychiatrist, counselor, therapist to indicate that there's an issue. I'm not doubting you, but I don't know that yet unless I have information from the horse's mouth, so to speak, regarding that. And as a result, I find you in contempt for failing to follow the court order on those weekends. I may add as well, by calling the friend of the court, telling them that you were going to do this, clearly shows that you had the intent to do this early on. And I find bad faith as a result of that as well. Is there anything you'd like to say before the court imposes disposition on this?
Yes, that week he started having panic attacks at school. I had to go pick him up Tuesday, the 14th, to go get him from school. He's having chest pain, shortness of breath. He did not want to go to his dad's. I got a text message from the school counselor that day. She was checking in on him because he has been seeing her regularly.
Okay, this has nothing to do with, is there anything you'd like the court?
This is why I made my decision on Friday to pick him up.
Well, I understand that, but you did this on bad faith as far as the court's concerned.
Mm-hmm.
And as a result of that, the proper method is if there's a mental health concern, file a motion with the court. Ask the court to suspend parenting time, for instance. That's not been done. You just did it upon yourself. And that's not proper. A moment. Court is going to order a sanction in the amount of $250 payable to the friend of the court, as this was done in bad faith. The proper method, again, is to file the motion. When you take the law into your own hands, there are consequences for that. Now, you're claiming that 4 days have already been made up?
The 3, the kids.
Well, according to the friend of the court, it'd be 4 overnights.
They spent an overnight December 20th, February 8th, and February 9th.
What dates again?
December 20th, February 8th, and February 9th.
Your Honor.
Yes.
Those are the dates. I don't believe the December one would necessarily count.
It doesn't.
After the fact.
It doesn't count.
But the other 2 dates, if those indeed were made up, that would be 2. So my calculations, I'm getting 3 overnights for the weekend of January 17th. And then I'm getting 1 overnight for the overnight of January 30th.
That's where I'm getting it to. Okay. So, Miss, February 8th and February 9th, were those your times?
Yeah.
Okay. Do you have any documentation or anything to indicate that you had this sort of agreement with Mr. Tulaski?
Just our conversations on app close.
Okay. So you have them with you?
I don't know if I have the conversations from that particular weekend.
When do you claim you made this arrangement?
So the tournament weekend would have been the 17th, so it was right after that. He would have had them the following weekend, and then he had them both weekends in February, the first 2 weekends in February.
Okay, well, I have. So are you saying you did this on the 17th? Had the conversation on the 17th?
We had a conversation the week prior to the 17th. He said that Ethan E. could go that weekend if I gave him every other week in February, because the children are often used as bargaining chips. And
Okay, well, I want to
yes,
get to,
and so
I just want to get
that
to your.
didn't work. That didn't work for me, giving up every other week.
Oh,
So
all right,
then
Miss, you're,
after the 7th.
excuse me,
Yes.
please, you're getting off the beaten path here. I'm trying to figure out when you had conversation with Mr. Talaski about February 8th and 9th.
It would have been right after that weekend then, because the first suggestion didn't work for me.
At the 18th. I don't see that nap close, but it may not have been provided to begin with. Sir, did you have the child on February 8th and February 9th?
Yes, sir, Your Honor. But that was to enable her to take Ethan to a tournament the following week on my weekend. So she provided me both E and T on her weekend. Yes, sir.
So did you have your weekend the next weekend?
I still had my weekend. T went with her to a tournament and excuse me.
Tournament.
Right. E went with her to a tournament on my weekend and.
So you lost that whole weekend?
Just with T. Or just with E, I'm sorry.
That makes more sense.
Okay. But that had nothing to do with the dates in question.
Yes, please.
Looking at the calendar, Your Honor, what I'm hearing is that the parties agreed to switch the weekend of February 7th and 8th for the weekend of February 14th and 15th.
Yes.
Court finds it's not been made up. 4 overnights will be ordered within the next 6 months, according to the friend of the court policy. Now, before we move on from this, and by the way, that $250 needs to be paid by April 4th. Before we leave, first, I'm glad to hear no one was injured in the traffic crash, according to my review of the file. But I want to make sure this is not on the screen. Sir, can you see that?
Yes, sir, Your Honor.
Who's in the picture?
That would be my son, T.
Is that a proper way to restrain the child?
No, sir, Your Honor.
Don't let it happen again.
Could I explain myself, Your Honor?
No, I just said, please don't let it happen again.
Okay.
That's it. It appears to be on a roadway. There's brake lights on.
It is pulling out of the parking lot at the school. And she did send me that picture, and I did send her the explanation behind it. And he was, before we reached 53, back in his seatbelt.
He needs to be in the seatbelt anytime the vehicle's moving.
He was. He does from time to time like to slip out of them, as all kids. And my saying when I put the boys in the vehicle is buckle up, Chuck. So they do tend to want to holler out the window at their friends, but I will put a stop to that.
Thank you. Lock the back window so it doesn't open.
It is, Your Honor.
Child needs to be restrained. I don't want to see that happen again.
Okay.
Best interest of the children. That'll be all. Thank you.
Can I do something, Your Honor?
Yes.
In regards to his second motion that he filed for the 29th, I had gotten a phone call from CPS on
Wait, what second motion are you referring to?
when I picked E up from school on the 29th. He says it was the 30th, but it was the 29th.
It's not a second motion, just the second motion.
Well, the second weekend?
It was the one night. I had gotten a phone call on the 24th from CPS saying that there was an open investigation against Brian. And I met with them on the 28th, and they told me what the allegations were. And part of the safety plan was to keep doing what I was doing, And just,
But where is the CPS worker to testify to that? You have to have the CPS worker here. That's hearsay. That's,
okay,
if there's a safety issue, bring your witnesses with you.
okay.
You have to, because otherwise it's hearsay and the court can't hear it. Just like if the child says, I don't want to go to dad's or I don't want to go to mom's.
I was just abiding by what we discussed when I picked them up on the 29th.
Okay, but that's your position on it. I have to hear it from the horse's mouth.
I know her report was not going to be done by today. So.
Okay. We'll continue to follow up with it. And if there's any issue, the court will probably see that down the road then. Good luck.
Your Honor, I did file a motion with friend of the court about her not reporting to me that Ethan was in a car accident.
That was also attached to today's.
Okay, I did see that. I did see that. Did the child have to be hospitalized?
No.
Do you think it'd be a good idea in the future, if there's an issue regarding the child, to keep dad or vice versa, to keep you in the loop?
We need to work on our communication issues because anything that is said to Mr. Tlaski is twisted around and used against me.
Well, I'm not here to judge that at this point, but what I'm here to consider is if there's any issue with the child that's of any significance.
There's no issue.
Please hear me out. If there's any significant issue regarding the child, and I see the photograph of what appears to be a bruise due to a seatbelt. Thank God, there's another example of why seatbelts are so important for young folks like that. If the shoe were on the other foot, as a parent, I would feel very concerned as well. So if there's anything significant regarding the children in any way, shape, or form, it takes 2 seconds to get on app close and say, this is what happened. Because take it, just for instance, and hypothetically speaking, not each of you, but if I and my bride had a child in common, ex-bride, in my example, though I'm not divorced, but I get the child back and I see a huge bruise on the back side, front side of the child, wherever the bruise may be, and I haven't heard from the parent, the other parent who had the child during that time frame, I'd be extremely concerned. And so you're right, the parties have to communicate better, and that's why app close is so important. It just takes 2 seconds. We were involved in a traffic crash, there will be a bruise on him due to the traffic crash because of the seatbelt. No medical treatment was sought, he's fine, he was evaluated, whatever the case may be, and then there's no arguing about it because you let him know. Vice versa, you would let her know in the same situation.
Absolutely.
So that's how I treat that motion. You have to communicate. And it doesn't need to be twisted, turned around against anyone. It's the best interest of these children. That's what it comes down to. We're done on this issue. Good luck to